thank you very much for joining us today. My name is Ian Scott, and I'm the founder of Scott Legal, and we're going to spend some time today talking about the extraordinary ability visas and green cards. And in particular, we're going to talk about the O-1 visa, the O-1B visa, the EB-1 visa, and the National Interest Waiver visa, or commonly known as NIW. A few things before we get started. The firm is a full service immigration firm, and we process a number of different types of visas, including the visas in the extraordinary ability category. Another thing that we want to let you know is that we regularly hold these webinars, having at least 2 webinars every month on different topics. And at the end of this webinar, we're going to send you out a few things. One of the things we're going to send you is the PowerPoint presentation. The other thing that we're going to send you, we'll send you 2 guides. So one guide is going to be on the National Interest Waiver, and the other guide is going to be on the EB-1 and O-1 Extraordinary Ability petitions. And the other thing that we're going to send you is a link where you can sign up for future webinars. Our panelists today, we're lucky to have Kelly Legrand-Wiener, who's the managing attorney of the firm, and Mikhail Razdova, who's an associate of the firm. Both Kelly and Michaela have a vast amount of experience in processing extraordinary ability visas. And again, my name is Ian Scott, the founder, and I will also be the moderator today. In terms of questions, you can list or include your questions in the chat function or the chat box, or you can include your questions in the question and answer function. We will get to all questions. Also, a number of people have sent in questions ahead of time, and we will go over those questions as we go through the presentation as well. And finally, this webinar will be recorded and will be made available on demand. So without further delay, I'm going to turn it over to Michaela and Kelly to start the presentation.
Hi, so good afternoon, everyone. So I will start the presentation by discussing O-1A visa, O-1B visa, and EB-1A green card. So O-1A visa is a non-immigrant visa for individuals who have extraordinary ability in the field of science, education, business, or athletics. And so how can someone qualify for an O-1A visa? So the standard for an O-1A visa is that you must be one of the very small percentage of people who have arisen to the very top of your field. And we'll discuss O-1A visa in more detail on the next slide. Now, O-1B visa is also a non-immigrant visa. An O-1B visa is for individuals who work in the fields of arts or in the motion picture or television industry. And the standard for people who work in arts and who work in the television, motion picture and television industry is different. So if you work in the field of arts, meaning that you are, for example, artist, like a painter, architect, designer, or something like that, then you must show that you have received a distinction in your field. And so what this means is that you will have to show that you have kind of sustained recognition substantially above that is ordinarily encountered in the field. And people in the field kind of describe you as prominent, leading, and you are well known in your particular field. Now, the standard for the motion picture and television is a little bit different. And if you want to qualify through that category, you will have to show that you have received an acclaim that is substantially above the one your peers received. And we'll again discuss O-1B visa in more detail on the next slides. And now EB-1A green card is a green card. So the difference is that the O-1A and O-1B visas are just non-immigrant kind of temporary visas. If you want to come to the US, the EB-1A green card is a green card, meaning that once you get the EB-1A green card, you can kind of move permanently to the US and you can make US your permanent residence. And so who can qualify for the EB-1A green card? So all the categories, as I mentioned above, all the people who work in the fields of kind of sciences, education, business, athletics, or arts, can apply for the EB-1A green card. And so the standard for the EB-1A green card is kind of like the highest. And when you are applying for an EB-1A green card, you will have to show that you are one of the small percentage of people who have arisen to the very top of your field, and you have kind of sustained a national or international acclaim, and your achievements have been recognized in your field. And again, we'll discuss the EB-1A green card in more detail on the next slide. And for all of these three categories, so O-1A, O-1B visa, and EB-1A green card, you have to meet the particular standard, and you also have to show that you are coming to the US to kind of keep continuing working in your field of expertise. So what you have to submit for this usually is either a letter from your future US employer, or if you will be kind of self-employed, you would have to submit contracts with future or potential clients. So now let's discuss the O-1A visa in a little bit more detail. So how do you qualify for the O-1A visa? So you would either submit evidence that you have received kind of a major internationally recognized award, like for example, Nobel Prize or Pulitzer Prize, Emmy, Grammy, like really like the highest award in the industry. So if you have received that, then that would kind of be usually sufficient. So you would submit evidence of the prize, evidence about the kind of about the organization that is granting the award, and just kind of objective evidence why the award you are submitting is kind of like the highest kind of internationally recognized award. If you don't have this award, which is I would say kind of like common for most people, then you would have to submit evidence that you meet at least 3 of these following criteria. So the first one is that you received a nationally or internationally recognized prize or award. So this would be an award that is, of course, like not the highest award, but still, you know, kind of recognized award in your industry. So if you have received any awards or prizes, then you would be submitting evidence, you know, like a photo of the award. Again, any evidence about the organization that is granting the award to kind of show that the organization is reputable, any objective information about the award, you know, what are the criteria, how can someone qualify and receive the award, and if there are any famous people who won the award in the previous years, then you could also mention their names. Now, the second type of evidence you could submit is evidence that you are a member in kind of prestigious associations in your field. And so what you would be submitting for this is kind of like a letter from the organization or association you are a member of, kind of confirming your membership and explaining in detail how can someone become a member of that association. Now, USCIS will kind of look if it's, you know, how can someone become a member of that organization. So if it's something just like you know, you send an email and anyone can kind of become a member, that would not really be helpful for the O-1A visa. So what you know, what they are really looking at is that the association should really kind of have detailed criteria how someone can become a member, and you know, should only allow kind of like the top people in the industry become a member, and in that case the evidence would be helpful for your case. Now, another type of evidence you could submit is kind of published material about you in media. So so for this, you would obviously be submitting kind of like the articles about you, kind of discussing your achievements, accomplishments in the field, And you would also be submitting kind of information about the media source where the article was published. So if you were, if Forbes, or New York Times or some like well-known media published article about you, that would be definitely helpful for the case, because that would show that you are one of the kind of like the top people in your industry. On the other hand, if some smaller media publish an article about you, it could still be helpful. But kind of like the well-known media or kind of like well-established media in your kind of particular field, that would be the most helpful for your application. Now, the other type of evidence you could submit is that you could submit kind of like evidence of original scientific or business contribution of major significance in your field. So this is kind of like a broad category. If you kind of discovered or kind of like registered a patent, or if you came up with some new kind of process or procedure, all of that could kind of fall under this category. What is important here is to kind of explain why the contribution is original, so why it's something new, and why it has major significance to your field. So to show kind of like the major significance, you could submit, again, media articles if media kind of discussed this accomplishment, or kind of like letters from people in the industry discussing why the contribution you made is important, and similar evidence like that. Then another type of evidence you could submit is if you kind of like wrote or published articles in professional journals or other media, then you could submit evidence of the articles. And again, kind of like the more prestigious the professional journal or the media source is, the better it would be for the O-1A visa application. Now, another type of evidence you could submit is if you are earning, or if you have been earning kind of like a high salary for your in your kind of current or previous job position. So for this, you would be basically submitting either pay stubs or W-2s to show that the salary was high. And you would also want to submit kind of objective evidence why you think that your salary is high as compared to kind of like other professionals in the industry who work in the same position as you. And then the last type of evidence would be kind of evidence that you have participated as a judge on a panel, and you have kind of judged work of others, of other people in your industry. So this could be either, if you have participated as a judge, you have been judging some competitions in your industry, or it could also be if you're kind of asked to review, to do kind of like a peer review for a scholarly journal, that could also fall under this category. And again, kind of like the more prestigious the competition is that you judged, the better would it be for the application. And a last type of evidence you could submit is evidence that you have been employed in either critical or essential capacity for kind of companies with distinguished reputation. So for this type of evidence, we usually submit letters from the applicant's previous employers that kind of discuss, on what position you have been employed, your achievements and accomplishments in the organization, and also kind of objective evidence about the company, to kind of prove that the company has distinguished reputation. And again, just to emphasize, you can either submit evidence that you received that one major international prize, or if you haven't received that, then you would have to meet at least 3 of the criteria as we just discussed.
Perfect. No, thank you very much, Michaela. And just a couple of questions and maybe one comment. One comment that I just had was with respect to one of the criteria that I think is often overlooked when people are putting together this type of petition is the judging the work of others. And often people think of that very literally in terms of, the way an American Idol judge or a can't can you dance or whatever those dance competitions are where they have judges that are picking the best group of dancers. But it's often not like that. This particular category, as Michaela mentioned, it could be that you're sitting on you could be evaluating journal articles. You could be you could sit on a promotion committee for an organization deciding who's going to get promoted, which is very different from evaluating individual staff because that can never be included. But if you're sitting on a promotion committee deciding amongst multiple people who's going to get promoted, we've used that as well. So you could think of the judging the work of others quite broadly. So then a few questions that came in regarding the O-1 visa, Michaela. One is just had to do with family and whether family can join in this particular process, and if they can they work while they're here?
Yeah, your spouse and your children who are unmarried and under 21 can come to the U.S. On and also apply for an O-1 visa, and the children can study in the U.S. The spouse can study as well, but the spouse cannot work in the U.S.
Okay, perfect. And then the other question that came in had to do with it may be the question's slightly different the way that the person wrote it, but I wanted to kind of the idea of can this particular visa lead to a green card? Does it turn
Yeah.
into a green card after a few years?
So not automatically, but many of our clients and many people in general who are in the U.S. for a couple of years on an O-1A or O-1B visa, which we'll discuss now, later after a couple of years, decide to apply for an EB-1A green card. So it doesn't kind of automatically lead to a green card. So it's not like if you live here for 5 years on an O-1A visa, you'll automatically get a green card, but many people later kind of decide to apply for an EB-1A green card.
Perfect, great. And then the last question has to do with, does the person have to be an employee of a company and get like, W-2 pay when they're on this
Yeah,
visa?
so not necessarily. There is nothing kind of in the regulations that would say that you have to be a W-2 employee. I would say it kind of depends on the work you are doing in the U.S. and kind of like field in which you are working. So many people who are here on the O-1A visa, I would say majority of them would probably be W-2 employees, but then some people who are here on the O-1B visa, artists, designers, architects, models, actors, and people like that. They usually are kind of employed by, or they have an agent, and then they work as kind of like independent contractors for many different companies. So it's not required, and it kind of always depends on the field in which the person is working.
Perfect, great, excellent, thank you.
So now let's discuss the O-1B visa. So as I mentioned, the O-1B visa is for people who work in the field of arts or in the field of the motion picture or television industry. And so how can you qualify for an O-1B visa? So the first way how to qualify is kind of similar as for the O-1A visa. So if you have received kind of if you have received or been nominated for kind of like a major internationally recognized award, like an Emmy or Grammy, then this alone could be sufficient for an O-1B visa. Or if you do not have this, then again, you would have to meet three of these following criteria. The criteria are kind of a little bit different than the O-1A visa, so I'll go over them quickly. So for the O-1B visa, the first way how you can qualify is to kind of show that you have been performing kind of a lead or starring role in production or events that have distinguished reputation. So just to kind of give you an example. So for example, if you are an architect, the production or events, those would be kind of like your individual projects. So how to meet these criteria. When you are an architect, we would submit evidence of kind of the projects you kind of the design, and evidence that they are distinguished, they have been discussed in media, and things like that. Now, the second way or second type of evidence you could submit is evidence of critical reviews or other published material by or about you in media. And so this is kind of similar as one of the requirements for an O-1A visa. So again, if any kind of like major media or any kind of distinguished media in your specific field kind of discussed your work and your accomplishment, we would be submitting evidence of that. So it would be kind of like the article and kind of like the why we think that the media source is distinguished, the magazines or the websites kind of circulation statistics, and things like that. Then another way, another type of evidence you could submit is evidence that you have been kind of performing a lead or starring or critical role for organizations or kind of companies with distinguished reputation. So again, for this type of criteria, we usually submit letters from your former employers that kind of discuss, why your kind of role in the company was either leading or critical to certain projects. They would again kind of discuss your accomplishments, and we would also be submitting kind of evidence about the former employer, why we think that the company is kind of distinguished. Then another type of evidence would be kind of evidence of major commercial success. So if you are, for example, a singer, you could submit kind of evidence of how many tickets have been sold to your concert, and things like that. But the major commercial or critically acclaimed success, that doesn't only mean the kind of like the evidence of tickets or kind of receipts or records. It can be kind of interpreted more broadly than that. Then another type of evidence you could submit is evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in your industry. So what we usually submit for kind of this criterion is our expert letters. And we will go over, expert letters for O-1 and EB-1A green card in more detail on one of the next slides. But generally, you would want to submit, couple letters from kind of key individuals in your industry that would discuss, your accomplishments, your achievements in the industry, and kind of like the more recognized the expert is in the industry, the more helpful would it be for the O-1B application. Then another type of evidence is that you have commanded a high salary. So this is the same as for the O-1A visa. So again, we would be submitting, pay stubs or payroll or W-2s or other type of evidence to show that you have, you have earned a high salary, and again, kind of objective evidence, why we think that the salary is high as compared to other people in your industry, working in kind of like the same area as you are, and on the same position as you are. And for an O-1B visa, if none of the above mentioned criteria apply to your specific kind of job or your specific industry, you could also submit a comparable evidence. But this is only for people who are applying for an O-1B visa if they work in the arts industry, and this doesn't apply for people who work in the motion picture or television industry. So now let's go over the EB-1A green card. So the EB-1A green card has the kind of like the highest standard. And that's when I mentioned that, you know, many people who are in the US on an O-1A or O-1B visa, you know, initially in a couple of years, they may decide to apply for an EB-1A green card. And usually when people are here on an O-1A or O-1B, you know, and they kind of plan to apply for the EB-1A green card in the future. You know, they usually need kind of a couple of years to work, you know, to kind of like build their kind of recognition in the industry, and kind of assemble certain evidence for the EB-1A green card, because the EB-1A green card is really for people who are in the very top of their industry, and they are internationally recognized as kind of experts in their industry. Now, the criteria for the criteria themselves are you know, pretty similar to the O-1A and O-1B criteria. So I will not go over those in detail again. But what is important to realize here is that you know, USCIS is conducting, when they are reviewing the EB-1A applications, they are conducting what is called a Kazarian analysis. And so what USCIS does is they you know, you again have to either have won kind of like a major internationally recognized award or meet 3 of 10 criteria. And so what USCIS does in the first step of the analysis is they look if you kind of meet, if you have either won the award or if you meet 3 of the 10 criteria. And this is kind of if you submit evidence that you kind of do satisfy the criteria, then you know, the kind of like the analysis in the step 1 is completed. Now, what is usually an issue, or you know, what requires kind of like extensive evidence in EB-1A petitions is to kind of show that you qualify under the step 2 of the Kazarian analysis. So in the step 2, USCIS is looking at the quality of the evidence. And USCIS will basically look at all the evidence you submitted and will make a determination if you know, if you are really one of the top experts in your industry, and you you know, you really achieve the international claim in your particular industry. So as an example, you know, so for example, about the judging. So there is for an EB-1A green card, you can submit evidence about to meet a criterion that you have participated as a judge in judging competitions or kind of reviewing, you know, doing the peer review. So under the step 1, you know, USCIS could well conclude that, okay, you have judged, you know, let's say 3 or 4 competitions, and you meet kind of like the step 1 in the analysis. Now, in the step 2, USCIS will look in kind of like very much detail, you know, so what was the competition you judged? You know, was it kind of like the top competition in your industry? They would want to know, you know, how are the judges selected for judging this particular competition? You know, how many judges are there? You know, if there are, for example, you know, 3 judges for kind of like very prestigious competition, that would definitely be helpful. They would be looking at, you know, who organizes the competition. Is it some kind of like well-known, prestigious association in your field? They would look at who are the other judges, you know, are the other judges kind of like top experts in the field. They would look at, who are the participants in the competitions, and things like that to kind of, and they would look at the evidence kind of together, and based if they think that, okay, this is like the really prestigious and you were chosen because you are one of the top experts in your industry, then you would, you would meet the step 2. But if USCIS would look at the all evidence together, and they would kind of conclude that, the competition is not doesn't select kind of the most prestigious people in the industry, then you probably wouldn't meet the step 2. So that's why even though the criteria themselves for the EB-1A green card look, and they are very similar to the O-1A and O-1B criteria, what is important for the EB-1A green card is to show the quality of the evidence, and submit kind of like a lot of evidence showing that you are kind of like really one of the top experts in the industry, and you are well known nationally and internationally in the industry. And that's why the EB-1A petitions often have hundreds and hundreds of pages to kind of meet the Kazarian requirement or analysis.
Perfect. Thank you very much, Michaela. We just have a few questions that came in related to both the O1 and the EB1. So the first one, maybe just the idea of, do you have to have an O1 before you go to the EB1? Do you have to first start off with an O1 and then later apply for an EB1?
Yeah, so not necessarily. If someone has been kind of living in a foreign country for many years, and the person is kind of already kind of like expert in the industry and is very well known, we may look at the evidence and assess that this person could already go for the EB-1A green card and has a kind of like a high chance of approval. But if we kind of like look at the evidence and kind of assess that, okay, you are, this person is kind of not kind of like ready to apply for an EB-1A green card yet, we may initially go for the O-1A or O-1B. The person can, live here for a couple of years and work on kind of assembling more evidence for EB-1A, and then later apply for the EB-1A. So it's not required that person is here first on the O-1A or O-1B, but many people first come on O-1, and then after a couple of years, we kind of assess that, okay, now the person may qualify for EB-1A green card and apply for the green card later.
Perfect. No, that sounds great. Now, there are a few questions and they're all related, so I'll just maybe phrase them in a different way so it'll cover all of them. But could you just talk about self-petitioning under both O1 and EB1 and whether that's possible? So, or do they always need an employer?
Yeah, so for the EB-1A green card, you do not need employer. So you can have employer, and then the employer can sponsor you, but you can also file what is called a self-petition. And in that kind of petition, you do not need employer, but you still have to show that you are coming to the US to kind of keep working in the area of your expertise. For an O1, you cannot file a self-petition, but you can kind of set up a company in the US. So for example, an LLC, and then that company in which you have ownership interest, that company can sponsor you, but you cannot file kind of just a self-petition like you can for an EB-1.
Perfect. Okay. No, that sounds great. And then the final question has to do with whether or not for either of these two visas, do you have to show the government that they can't find, qualified U.S. workers?
Yeah, so you don't have to for the O1, and even for the EB-1A green card, you do not have to show it because just the EB-1A green card is kind of like really for kind of like the top people in their industries, and US just wants these people to apply for a green card and come in, so they don't they don't have to show that they can't find US workers.
Perfect. Great. Excellent. Thank you.
And now Kelly will talk about the National Interest Waiver visa.
Thank you, Michaela. Yes, so the National Interest Waiver this is another green card category. So similar to the EB-1A, you would get a green card if you qualify for this visa. It's in the EB-2 category, which means that as a threshold requirement, you must either have an advanced degree or its equivalent, a bachelor's plus 5 years of post-baccalaureate progressive work experience in the profession, or you must be able to show that you have exceptional ability. And the criteria for exceptional ability are listed on this slide. They are somewhat different than the criteria for extraordinary ability. So it's good to kind of take a look at these and see if you qualify. For example, 10 years of full-time experience in your occupation, a degree, things like that. So even if you don't have the advanced degree and you don't have the bachelor's plus the 5 years of experience, it still may be possible to qualify for the national interest waiver. The second big piece of the national interest waiver is, and the thing that makes it different from a normal EB-2 is that you can waive the requirement of a job offer and the requirement that you go through the labor certification process. So the labor certification process is that process where you have to test the labor market and see if there's any willing, qualified, and available US workers. The benefit of the national interest waiver is you skip that process and you can self-petition, similar to the EB-1A. So, to demonstrate that you qualify, you have to meet the 3 criteria listed on the bottom of this slide. So showing that your endeavor has substantial merit and national importance. It's good to know this is appropriate for a wide variety of areas such as business, health, education, technology, science, entrepreneurs, any endeavors that kind of further human knowledge in key areas, for example, medical advances in technology that might have applications for the military, or produce a strong economic impact. These things can have substantial merit. You also want to look at whether the endeavor has national importance to the US. So you want to look at future impact. Are you producing something that's going to increase the US's competitiveness in a certain area? So those are all good things to consider. Secondly, you need to prove that you are well positioned to advance the proposed endeavor. So this criteria really focuses on the applicant, their background, and their accomplishments. It's definitely different than the EB-1A, where you have to have risen to the very top of your field. So sometimes people that may not feel they're yet at the EB-1A place to meet those criteria, maybe they feel more comfortable with the NIW. Because in this case, if you are able to show you have a strong track record of success in this area, for example, if you're an entrepreneur and you want to do this for your business and you've been running the business successfully for 10 years, that would be good evidence that you could use to show you meet this criteria. And then lastly, you have to show that on balance, it would be beneficial to the US to waive the requirement of the job offer and the labor certification. And here is where you would look at, is it impractical to secure a job offer? So if you're an entrepreneur, the labor certification process doesn't really work for you. So it's good to bring that up. That can be a reason to qualify for the national interest waiver. You can also show that the national interests that are being served by your contributions are so important that it's urgent that the labor certification be waived. And then additionally, you could argue that even if there are other qualified workers doing what you're doing, your contributions are going to be so important and of such substantial merit that it would, again, be beneficial to the US to waive the requirement of the labor certification.
Thank you very much, Kelly. A couple of questions that came in regarding the national interest waiver. So the first one has to do with the advanced degree, and really the question of whether or not the degree has to relate to the endeavor at all.
So I think that while that's not specifically in the regulations, generally yes. It's not, again, so there may be ways that you could be creative about it, but generally the degree, well, maybe not an explicit requirement that it has to relate, should ideally relate to the endeavor that you're involved in. So obviously, if you're an entrepreneur, like the degree may be something that's a bit different, but if you can make a logical connection, you could use it to qualify.
Perfect. Excellent. So speaking of entrepreneurs, could you give us like maybe just an example, walk through an example of an entrepreneur, like a hypothetical case of an entrepreneur that would be able to get an NIW as it applies to these three prongs?
Sure. So one example that comes to mind is kind of an engineer who was starting a consulting company that was related to, this person had obtained a patent that was based on how to advise companies on how to automate their workforces to best utilize technology while not losing any jobs. So kind of part of the patent was how to retrain workers, so that you're not creating job loss. What was argued, was that the endeavor had substantial merit and national importance, given that job creation is extremely important. So that was on two levels here. The company had a business plan that showed it was going to not only hire U.S. workers, but also that by its very nature, what it was focused on was how can we help U.S. businesses become more competitive while not actually losing jobs. So a lot of market research and newspaper articles and things were included that talked about a lot of the concern, about job loss and how jobs will be lost to technology over time. And so that was able to show that that had substantial merit and national importance, kind of the job creation piece and the ability of the company to serve an important national interest in helping companies to stay competitive while not losing jobs. For the second prong, the person was an engineer that had over 40 years of experience, so was able to gain, letters from many experts in the industry, as well as people, business partners who wanted to work with the company, speaking to their background and their track record of success in this particular area. And those letters were also used to bolster the substantial merit and national importance of this undertaking. And then finally, showing that on balance, it would be beneficial to the U.S. to waive the requirements of the job offer and the labor certification because this person was an entrepreneur that was going to wholly own their company. The labor certification was not appropriate for them. It's impractical to obtain a labor certification. You cannot obtain one if you are the sole owner of the company. Additionally, it was able to be argued that even if other people were doing this line of work, the type of work that he was doing and the type of services he was offering, to U.S. companies was important enough that even if other people were working on it, it was, on balance, it was beneficial to waive the job offer requirement.
Perfect. Excellent. No, that sounds that sounds good. And I think that often happens that in the third prong, you're often using some of the same arguments that you used in the first prong, which are very useful. The final question, or it's maybe a group of questions, just procedural. Just how long does it take to get this visa, and can family join with it?
Sure. So yes, family can join. Your spouse and your children who are under 21 can apply for the green card with you as dependents. In terms of how long it takes, the NIW has two parts. One is that you file what's called an I-140 petition. The second is you file either an I-485 green card petition or you file for the green card at a consulate abroad. The I-140 for the NIW cannot currently be premium processed, which means premium processing is a process where you pay $2,500 to the government to get a response within 15 calendar days. That's not yet available for the NIW, although it may become available. So that means that you're looking at several months. I think right now it's around somewhere between 6 to 12 months, to get an answer on that first part. If you're in the United States and the EB-2 category is current for you, so that means that there's no backlogs in your category, then you can file the I-140 and the green card I-485 application together. You can file for work and travel authorization when you file that. You have to be in the